Greetings, I'm Shireen Nisha. Now let us look into the formal sources of international law. So, international law devotes a great deal of attention to its sources. Scholars have produced a large body of work about both the conditions under which treaties, customs, or general principles of law bind actors and the hierarchy among the various doctrinal forms which might apply in each instance. The discussion usually revolves around the classic sources contained in Article 38 of the Statute of International Court of Justice, where it enumerates the various sources to examine the law necessary to resolve a case. So, what is customary law? By definition, customary law comprises customs that are accepted as legal requirements or obligatory rules of conduct, practices, and beliefs that are so vital and intrinsic part of a social and economic system that they are treated as if they are laws. Customary laws are also defined as consisting of established patterns of behavior that can be objectively verified within a particular social setting. Custom is regarded as an authentic expression of the needs and values of the community at any given time. The two basic elements in the makeup of a custom is material facts and opinio juris. Material facts is the actual behavior of states, and opinio juris is the psychological or subjective belief that such behavior is law. The basic rule as regards to continuity and repetition was laid down in the Islam case decided by the International Court of Justice in 1950. The ICJ stated that some degree of uniformity was important because a custom could come into existence, which is in the case of Anglo-Norwegian fisheries case. The court declared that customary rule must be in accordance with constant and uniform usage practice by the states in question. In the North Sea continental shelf case, the court took account of the fact that the Federal Republic had not ratified the convention and held the equidistant principle was not inherent in the basic concept of continental shelf rights, and the rule was not customary international law. However, the court emphasized in Nicaragua against United States that it was not necessary that the practice in question had to be in rigorous conformity with the purported customary rule. Once the material facts has come into place, it is important to consider how the state views its own behavior and the opinio juris or belief that a state's activity is legally obligatory, which is the factor that turns the usage into custom and renders it part of international law. The Lotus case was where the opinio juris was noted as an essential element in the formation of customary law. Treaty, on the other hand, is one of the most binding forms in which a state can express its consent. A treaty, in common with all other forms of contract, must have parties of legal capacity to enter this form of contract, and it must be in written form. The only parties having legal capacity for this purpose are independent states, and this is stated in Article 2 Sub 1 Sub A 1969 Vienna Convention. A country that hasn't signed the treaty has no obligation to follow its norms. Article 26 of the Vienna Convention of the Law of Treaties deals with the Latin maxim pacta sunt servanda. Every signatory is to follow the treaty in good faith and is in binding upon them. This forms the basis of every international agreement, and having that in mind, the principles of international law embodied in the Charter of United Nations. The important treaties one may mention is the Geneva Conventions on the treatment of prisoners and the protection of civilians. Lawmaking treaty is an awkward notion. Lawmaking treaties are those agreements whereby states elaborate their perception of international law upon any given topic or establish new rules which are to guide them for the future in their international conduct. Examples of such treaties may include the Antarctica Treaty 1959 and the Genocide Convention 1948. There are also agreements that codify existing customary rules, such as the Vienna Convention on Diplomatic Relations of 1961. However, parties that do not sign and ratify the particular treaty in question are not bound by its terms. Now, let us look at the relationship between international law and municipal law. According to legal theory, each state is sovereign and equal. However, in reality, with the phenomenal growth in communications and consciousness, and with the constant reminder of global rivalries, not even the most powerful of states can be entirely sovereign. To understand the relationship between international law and municipal law, it is important to know the link between the two laws. International law is a set of rules and actions related to national behavior. In other words, international law is a set of rules that apply when states interact. On the other hand, we have municipal law. Is also known as national law of the country, and it governs the domestic aspects of government and deals with issues between individuals and between individuals and administrative apparatus. Now, let us look at international law in the municipal law of the UK. As far as the UK is concerned, various theories have been put forward to explain the applicability of international law in the UK. A rule of international law will become part of national law after the transformation of it into national law by means of a statute or an act of parliament. The doctrine of incorporation has become the British approach. In the case of Bouvot against Barbour, Lord Talbot declared that the law of nation in its full extent was part of the law of England. However, in the 19th century, there were changes to the approach, which led to the case of R against Kine, where the court came to the conclusion that no British legislation existed which provided for jurisdiction over the 3-mile territorial sea around the coast. The opinions were also put forward in the West Rand Gold Mining Company case. Lord Elverston declared that whatever had received the common of civilized nations must also have received the assent of Great Britain, and such would be applied by the municipal tribunals. The very first limitation on the traditional doctrine of incorporation can be found in the case of Mortensen against Peters, 1906. It was held that an act of parliament had been duly passed and assented to was supreme. The court had no option but give effect to its provisions. The Transact Trading Corporation Ltd against Central Bank of Nigeria raised anew many of these issues. The case concerned a claim for sovereign or state immunity by the Central Bank of Nigeria. Previously, the doctrine of stare decisis would apply in cases involving customary international law principles, and this was reaffirmed in the Thai Europe Tapioca Service Ltd against the government of Pakistan, 1975. Now, we will look at international law in the domestic Malaysian courts. The practice and state in respect of reception of international law is basically reflected in its constitutional law. In practice, the courts in Malaysia appear to have applied customary international law when the occasion arose, although the application is not direct but through the medium of English common law. In other words, Malaysian courts apply customary international law as part and parcel of common law. Article 74 sub 1 of the Federal Constitution stipulates that Parliament may make laws with respect to any matter that is within the federal or concurrent list of the 19th schedule, as well as Article 76 of the Federal Constitution. For example, the rule of customary international law relating to the immunity of a sovereign state from judicial process of a foreign country has been applied in the case of Olofsson against Government of Malaysia, where it was held that as Malaysia had become a sovereign state as from August 9, 1965, the court had no jurisdiction to entertain any action or proceeding against the government. In PP against Oi He Koi, the accused were captured during the Indonesian confrontation campaign against Malaysia. The federal court allowed the appeals of the accused on the ground that they were prisoners of war and entitled to the protection of the 1949 Geneva Convention. In conclusion, the two principal sources of international law as set out in Article 38, which is custom and treaties, are an assurance that common consent of states is the basis of international law. They are also an indication that in context of the organization of the international community at present, the will of the states normally predominates in the creation of rules of international law. As for international and municipal law, it can be seen that most states do not accord primacy to international rules in their national legal system. This shows that they do not want to tie their hands formally with the international rules, but that does not necessarily mean that they don't follow international rules. Courts may play a crucial role in ensuring compliance at national level with international legal standards. Passing of municipal law regarding body of individual international law bolsters this body of law but does not create these rights and obligations. Thank you.